Good morning. It's the appointed time. We have a quorum. I will now invite representatives of the administration to come inside the conference room. We have in attendance today Mr. Kenneth Ching, Deputy Director of Environmental Protection, Waste Reduction, EPD, Mr. Steve Wong, Assistant Director, Waste Management, EPD, Mr. David Lai, Principal Environmental Protection Officer, Waste Management and Strategy, EPD, Mr. Philip Lee, Principal EPO Territorial Control, EPD, Ms. Amy Wong, Acting PAS for Environment and Ecology Sustainable Development, Ms. Selena Lau, Senior Assistant Law Draftsman, Law Drafting Division, DOJ, Ms. Janice Leung, Government Counsel, Law Drafting Division, DOJ. We are now at section 142, that is for the blue bill. The page number is C2343, and for the marked up copy in Chinese, page 48, Ms. Khan. Yes. Excuse me, Chair. Yesterday, in our scrutiny, I have some questions about the provisions we looked at. 140 and 141. So these sections require retailers to provide rebates and set up some returning points. But we also have, in particular, the designated operators. So, for the retailers to provide rebate and the returning points, where would the resources come from? Would they come from the operators, or is it that the retailers would be responsible for the return points? Can you please provide a response to the questions Ms. Khan asked today, and what Ms. Khan asked about a timeline? We are now providing a response. We have prepared a PowerPoint slide for the timeline. So, from January 2026, if they are to distribute the relevant resources, they are to recycle by January 2027. And it just is a rolling basis when the products are distributed between January and December 2027. By extension, they are to be recycled between January and December 2028. And you can see the arrows basically move down 1 year. And it would go all the way to, say, 2028, and the products that are distributed within 2028 are to be recycled in 2029. Now, take 2027 as an example. It will be that the number of plastic bottles recycled in 2027 divided by the number of products distributed in 2026 times 100%, that would make for the recycle rate in 2027. For section 140, it is about how retailers, there are some particular requirements, say the scale, the area of the retailers, and the retailers must provide a rebate of a value not less than the prescribed amount, and we are currently planning to set that to be 10 cents. Now, for section 141, why are we distinguishing between registered suppliers and registered scheme operators? It is because at different stages of the process, we want to have this market-oriented approach. So the suppliers are to pay for the different arrangements, that is, say, rebates and whatnot. But then we also have scheme operators. They have some responsibilities as well. So we are saying both categories of parties would have to provide rebates. And when it comes to certain requirements of retailers, they are to provide rebates if they reach a certain size, basically. But they can also get the suppliers or scheme operators to set up return points. In the end, that would come from suppliers, the source of the rebate. Ms. Khan, I think from the wording of the sections, I would have a different interpretation. Section 140, retailers have the responsibility to set up return points. And in accordance with this section, this subdivision is about rebates. And here it says the retailer must provide a rebate of a value not less than the prescribed amount. It does not say, as the assistant director said, that it would come from the supplier. It only says here the retailer must provide a rebate of a value not less than the prescribed amount. It also does not say what the prescribed amount is here. The prescribed amount will only be set out in the subsidiary legislation. What I have a problem is, in particular, it does not say that the rebate should come from suppliers. For Section 141, it is about how the registered suppliers and the registered scheme operators should provide rebate. And if the size of retailers exceeds 400 square meters, they are to set up return points and provide rebates. But return points can be set up elsewhere as well, right? Outside of retailers. For these other return points, the rebates are to be provided by suppliers and scheme operators, right? This is my understanding. At least that is what I understood from the wording. If that is not your intent, I think there have to be amendments. Director. Or Deputy Director. Well, it is the case that return points can be set up elsewhere. So Ms. Khan's understanding is correct. Say if the return points are set up in shopping malls, the shopping malls are responsible for providing rebates. For retailers who are not suppliers or scheme operators, if they are selling the products and their sizes, their areas exceed what we set to be a threshold, they have the responsibility to provide rebates. But they can always partner with other parties. Then they would have to pay the rebates themselves. But according to our understanding, the retailers would work with suppliers and scheme operators to set up return points. And if there is such partnership, the rebates, as long as a rebate is provided, the retailers would be seen as having fulfilled their responsibility. As for where the rebate comes from, it would depend on the arrangements between the retailers, suppliers, and scheme operators. If a rebate is not provided at the retailer's return point, then it would be the responsibility of the retailer. The retailer would be liable, essentially. I think it makes sense because if there is a commercial arrangement that makes the scheme operator pay the rebate, and it is deemed worthwhile by the scheme operators or suppliers that they should have such arrangement. It makes sense. Sorry, I have more to say, Chair. I also want to talk about the timeline. Regarding what you have here, the designated periods, basically you would have a designated period for distribution in 2026. The products are to be recycled in 2027. I think it is very clear if you delineate the periods by the years. I want to ask in particular about the formula. It is said that it would be determined by weight, not by the numbers. But the rebates are issued by the numbers. So regardless of the size of a bottle, one would be entitled to a 10-cent rebate. So what you have in mind here, having weight be the basis of calculation, is that agreeable to the stakeholders? And how can one get the information about the weight? Can one scan the barcode and tell what the weight is, or do they have to weigh everything in the end? Thank you. Assistant Director. When we liaise with the industries, we understand that with downstream operators, they would calculate the recyclables by weight, which is why we adopt the basis of net weight in the calculations. And when the suppliers register the relevant products, they will submit information about the net weight of their products. Say for the products they distributed within a certain year, the net weight of such products. So it would be easy for us to calculate the figure in the following year. Well, is it the case that it would be a sum of the net weight of the products recycled and the products distributed, so that you can derive the percentage? Mr. In Kong. I have a quick question about section 140. I have a suggestion in the English version. In subsection 1, line 7. With this proposed new section, when we talk about a Schedule 12 product, can you simplify the wording a little? Here it says who returns a Schedule 12 product of the type to the return point. Before, you would just say a Schedule 12 product. Wouldn't that suffice? Or a type of Schedule 12 product. Because here the wording is quite strange. A Schedule 12 product of the type. I think you can review the wording after the meeting. When you say a prescribed recovery period, you also say a type of Schedule 12 product. Or when we were looking at section 120 something, you also said a Schedule 12 product, say in section 129.1. Can you not say a Schedule 12 product of the type? It just is very weird to me. Can't you adopt a more consistent drafting approach? Thank you. Ms. Lau. Thank you, Mr. Kong, for your observation. Since we want to have a common legislative framework, it is a bit more complicated. A Schedule 12 product can be bottles, can be tires, can be batteries in future. So any of the aforementioned can be a Schedule 12 product of the type. And if we have one returning a particular bottle, that would be a Schedule 12 product of the type instead of a type of Schedule 12 products, because they're not returning, say, multiple bottles. Well, in that case, I think you can define this. Say you can have a definition of a Schedule 12 product or a Schedule 12 product of the type, because they sound vastly different to me. Mr. Ching. Well, let me put it this way. For this subdivision, we have included references to other sections. So it may be something that is not in Schedule 12. But plastic bottles would definitely be entitled to rebates. When we get to Schedule 12, things should be clearer. So if some of the Schedule 12 products are entitled to rebates, we would say they are a Schedule 12 product of the type. Because I think if you say a type, it may be the case that everything in Schedule 12 will be entitled to rebates, which is why we say in particular here of the type. Well, I think either way you can review Ms. Doreen Kong's suggestions, Mr. Chen Xiu-hong. I have some clarifications to make with the administration. So we have a recovery rate set. You have a minimum recovery rate, basically. And regardless of who is responsible, the suppliers or the third parties engaged, say the scheme operators, they must meet this recovery rate. If they cannot meet the recovery rate requirement, there will be penalties. But this does not involve retailers, unless the retailers themselves are also scheme operators. So Section 140 here basically is the only requirement for retailers to set up return points, and with return points they are to accept Schedule 12 products of certain types. The retailer must provide a rebate, but the retailer will not be subject to the minimum recovery rate requirement. So what would be entailed in the partnership? Basically, retailers would just pay the absolute minimum, and what is going to happen to the products collected by retailers? More likely than not, they will hand the recycled products to suppliers or scheme operators, but the amount to be paid then would not be the prescribed amount, right? I think Ms. Kamen Khan asked a similar question. Well, I think it is somewhat different. I think the problem, my question lies with responsibility. The member's understanding is quite correct. What the retailer said for Section 137, we are talking about the requirement to set up registered return points. We did not specify that the returned products must be handed over to suppliers and scheme operators as long as they're recycled in the end.
2 questions. What if a recycler doesn't hand over the recyclables to the manufacturers? It's like a hypothetical question. Well, in that situation, if a manufacturer doesn't seek assistance from the scheme operators, they will have to report to us, say the number of recyclables collected. If these recyclables have been given to the downstream recyclers, then they will not be counted towards the target, but then they will still have to report the figures to us. That's exactly how we can arrive at the recovery rate. I believe retailers don't want so much hassle either. They may seek help from a recycler. Thank you. Mr. Chen. There is some prescribed amount that is no less than 10 cents. What about a producer meets the minimum recovery rate? When the recovery rate reaches 40%, and when a register return point has been set up, money has been spent. What about these situations? Currently, the target is set at 30%. What about when the figures reached 80% or 90%? Probably what I mentioned wouldn't happen. But at the early stage of the implementation of the scheme, probably the retailers may make a complaint. I'm not sure if Mr. Peter Shield is aware of that. The scheme operator is required to pay 10 cents, and the producer has no responsibility for paying to take these recyclables back. As 10 cents must be paid. So what if they simply store the recyclables somewhere, or they simply give them away as gifts? Thank you. Deputy Director, just a simple answer, yes or no. When it comes to the details of the actual operation, say plastic bottles, when we recycle these, or when we recover these plastic bottles, they are actually of great value in the market. When they can be conveniently recovered, well, I understand, Deputy Director, you may simply give a simple answer, yes or no. Mr. Chen, well, I believe so, yes. Let me give you one more scenario. Just now I talked about a scenario where a retailer might recover a batch of containers, but then no one is going to pay to recover these recyclables. But what if a producer falls short of the target, that is 30%? Then they may have to pay more than 10 cents to look for more retailers. Therefore, retailers may receive more than 10 cents, and these will go towards the profits of the relevant retailers. This is a possible scenario, right? Administration? Yes, what Mr. Chen mentioned is indeed a possible scenario. Under 138(2), the director may impose on the registration any term or condition that relates to a prescribed matter. So we may make adjustments to the number of return points or the operation hours of the return points. they will try to meet the target according to the recovery rate or the target recovery rate. That will make it possible for citizens to send these recyclables for recovery. I believe many scenarios will happen or may take place under the producer responsibility scheme. Say what Mr. Chen mentioned, this is indeed one of the possible scenarios as well. Alright, let's continue. Well, hang on, Mr. Peter Schill. Chairman, I'd like to follow up on Mr. Chen's question. Just now, we said that retailers need to provide at least 10 cents for the recovery, and in the future, there may be recovery of some machines. Or for supermarkets larger than 4,000 square feet, plastic bottles will have to be recovered. They have a large area and they can accommodate these bottles. 10 cents, the retailers have the responsibility for paying them. So when someone simply walks up to get back the recyclables, do the retailers need to pay 10 cents to the person concerned? Then probably that may lead to the storage of plastic containers, and that will be different from the scenario we were talking about. Say for a supermarket or large stores that are even larger than 4,000 square feet. Well, what if a supermarket that is less than 4,000 square feet? Well, then that supermarket doesn't have to set up a return point. What if someone simply walks up to a store and says, I'm going to give you a plastic bottle, then does the retailer need to give 10 cents to the person concerned, Deputy Director? No, if the store isn't larger than the prescribed size, that is 4,000 square feet, then he or she doesn't have to give the person concerned 10 cents. So why is Mr. Chen's scenario possible? Well, for stores larger than 4,000 square feet, we know this situation will arise. That is within our prediction. Legislation mentions 10 cents. Well, let's go on. Page 0048, Division 8, Fixed Penalty and Related Provisions. We have drawn reference from the fixed penalty of other policies, so the contents are almost identical. All the way to 0058, Division 8 mirrors the principles as well as the fixed penalties of another piece of legislation or policy. So let's see if members have any questions. Mr. Kong, under 143, for 5 types of offenses, you will issue penalty notices with the penalty amount of $2,000. Actually, this subsection covers a lot of offenses. So why did you only select these 5 types of offenses? From 1312, say for 129, isn't covered under the penalty notice. $129 is just an example. Can you tell us the principle for including the penalty? Can you give us more details? Thank you. For offenses related to fixed penalty notices, the severity of the offenses is relatively on the low side. Some offenses may lead to penalties at level 6, pending determination by the court. These are more serious offenses. That's why we have provide for different levels of penalties in relation to different offenses. Thank you. I'd like to ask about barcodes and logos. Well, failure to affix barcodes and failure to affix logos, these differences are actually very fine. And I'd like to ask about 1433. A penalty notice may be given to the person personally or by affixing it to the person's place of business. What about in the situation of a hawker? Assistant Director, well, under 143(3), let me give you a real-life examples. We have drawn reference from a policy last year under 143(3) that concerns the manner of the delivery of a penalty notice. We use the word or, say for plastic tableware, after inspections when we find non-compliance, say when a styrofoam container is distributed to customers. If there is non-compliance after reminders or warning, then a penalty notice will be given to the restaurant by our staff member. We use the word or to safeguard and other law enforcement option for the Hong Kong government. Say, when a store has closed, we could as well affix the penalty notice to the person's place of business, and this is actually more flexible for the administration. That is an approach in addition to giving the person the penalty notice. Mr. Peter Shield. Logos have to be affixed to a plastic bottle. Some beverages may arrive in Hong Kong in batches. So when a logo is printed, a logo cannot be directly printed on individual plastic container. Say Yakult as an example. These little bottles came in a package, so how can we actually affix different logos or barcodes on these small beverage containers? Well, we have made exchanges with different operators. Say for some juice or bottled juice, they will make adjustments to the production or manufacture on these products. For importers that import beverages from overseas into Hong Kong, they will discuss with overseas operators to see if there is any room to change the design, or logo may be printed or affixed to the outside of the plastic beverage container. As long as there's a logo, then that'd be fine. Mr. Peter Shield, say for some products that come to Hong Kong very often in massive batches, probably the overseas production line will try to meet our requirements. But what if some products don't arrive in Hong Kong in a large batch? Probably only a small number of these products arrive in Hong Kong for sale. The bottles may not have such logos or barcodes. In this situation, is there any alternative? Say probably when logos or barcodes could be simply affixed to the containers instead of having logos or barcodes printed on the containers. We are discussing with the trade, and the practice is to affix the barcode or logo to the beverage container, but then we will still be liaising with the industry to identify any difficulty and see how we can strike a balance in a discussion of subsidiary legislation. Thank you. Well, I hope products that don't come in large batches will also be able to have a solution. Mr. Andrew Lam, speaking of rebate, we understand 10 cents are given to the person concerned. Yesterday we talked about what is meant by cash. Any vouchers or by electronic means, say e-money. In real world, no matter how large a retailer is, I don't believe a retailer will have tens of thousands of 10 cents coins in the stores. So probably we may find tokens or alternative more common. In the stage of subsidiary legislation, we need to work on it. What if a machine is out of order? How are we going to deal with that? Sometimes the tokens don't target any individual act. Say in a membership system, when you join the membership, probably you will be able to exchange for some tokens. So when we work on subsidiary legislation, we need to tread very cautiously. Alright, so Mr. Lam is reminding the administration. Thank you. Ms. Carmen Khan. Well, I understand the administration just now said that you had drawn reference from plastic tableware in drawing up the penalty mechanism. Just now, as Ms. Doreen Kong suggested, you need to tell us why you chose 131 brackets 1 and bracket 3. We are talking about a penalty at level 6. That is about 100,000. Is that correct, legal advisor? Deputy Director, it's $200,000. Legal advisor, $100,000. 143 brackets 2. You mentioned by paying a fixed penalty of $2,000 within 21 days. But if someone complies with the fixed penalty notice and paid the penalty, then you cannot continue with prosecution. And these offenses aren't strict liability offenses. Legal advisor told us about some provisions. These provisions allow the person concerned to raise defenses, and these are not strict liability offenses. These are rather minor offenses. It's possible that one can put up a statutory defense. Can you give us more details? Why did you choose these provisions? Before giving the floor to the Assistant Director, I'd like to remind members, as well as the administration, I understand for these parts, the context may be quite direct and straightforward, but probably you can take us through these straightforward provisions one by one. At least you need to tell us what these provisions mean, or what these provisions are about. Thank you. Assistant Director. Well, I'd like to talk about 131 bracket 3 and the other provisions. Offenses relating to the use of prescribed logo, registered suppliers required to meet recovery target, service of assessment notice on failure to meet recovery target, and so on. Just now, Ms. Carmen Khan talked about conviction after the fulfillment of the penalty notice. We have actually drawn reference from other offenses. These are quite minor offenses, so we adopt the approach of fixed penalty notices. We penalize the people and then we want them to mend their ways. However, if they continue to breach the law, in case of repeated violation of law despite the issuance of notices, These cases may be taken to the court for summons hearings. Then, upon conviction by the court, the person concerned may be fined at level 6 penalty. So in the actual operation of law enforcement operations, we will first of all issue fixed penalty notices in case of non-compliance still. Then we may take the case to the court, and then the person concerned will be fined. It's about the order of our law enforcement operations. Thank you.
Ms. Khan, looking at the ordinance, let's say 131. If there is no prescribed logo, that is the PRS, the $ logo, or when you use this prescribed logo, you are not using the real one but the fake one, then this kind of behavior will be regulated under Section 131. This is exactly what Peter Schill worried. If the retailer is using a fake logo or an unidentifiable logo, that will be a criminal responsibility. This is what is stipulated under 131. And in 132, you are not just regulating the large-scale retailer, because here it says any retailer. It is talking about any retailer who is selling or distributing products. It is requiring them to sell products with a prescribed logo. So not just the large ones, even the small stores, they cannot sell any products without a prescribed logo. If they put it on shelf, then this is a offense with mens rea, so there is no strict ability. And we are giving it a very brief mechanism, that is to serve them with fixed penalty notice. In 137, it concerns the setting up of registered return points, and it is targeting at a large-scale retailer. I hope you can explain to us, because you have singled out these offenses. Is there any considerations? Are you looking for a speedy mechanism? Because if you need to go to court for all these procedures, you are burdening the court. And if I authorize you to set up this speedy mechanism, I believe that it will be reasonable. Can you please explain to me, are you expecting a lot of offenses, or is it because these are just some initial violation? Is it 148 that talks about the recollection? I agree with your comment, Chairman. I believe that we need to go through section by section. Going back to the question of Ms. Khan. As we determine the sorts of penalty, be it the fixed penalty notice or going to the court, first of all, we will consider the severity of the offense. Second, we will also consider about the time, because we don't want to put any hindrance to the operation of businesses. But not all offenses can be treated with fixed penalty notice. If there are people who is trying to avoid these kind of responsibility, then I would not penalize it with fixed penalty notice. That will be subpoena. Or if you fail to submit your audit report, I believe that these are some rather important requirements. If you fail to fulfill the requirement, you will not be just served with a fixed penalty notice. Let's say if a certain retailer is selling a product without a logo, maybe it is registered or not registered. Perhaps they are selling a product without prescribed logo without knowing. When we spotted it, we will serve them with a fixed penalty notice. If you have to prosecute it for even such offenses, it will be quite a nuisance. And it is something that is quick to fix. In PRS, these kind of offenses does not show that they are avoiding their responsibility in recovering their products. That's why we are making these kind of choices. Ms. Khan, no further questions. Ms. Doreen Kong. I have a quick question. I appreciate the questions from Ms. Khan because it helps me clarify a number of points. After looking at the drafting, I cannot see why these 5 types of offenses are being singled out. But now I understand because the administration has explained. But when I look at 143, you are authorizing the director. It says that they may give penalty notice. It seems that you are giving a lot of discretion to the frontline staff. For the same offense, you can serve them with a summons and penalize them with a level 6 fine. And for the same offense, the director may give them a penalty notice. You are giving huge discretion to the frontline staff. Will there be any guidelines? Will there be detailed working guidelines? I am quite worried about this. Second, the repeated offenses. I'm asking all my questions at once. Let's say there are some repeated offender. Are you going to penalize them with just $2,000 or you are going to serve them with summons directly? It is unclear in the drafting. And also about Section 145. I know that it is in a cluster, so I would like to ask all my questions at once. After serving these penalty notice, they need to ask for the information of that individual and the company. In bracket 3, a person who fails to comply. If a person failed to comply to provide information, when you say a person, does it include the staff? Because I'm thinking of the convenience store. If you are asking just one particular staff, sometimes he or she may not know so many information of that company because he's only serving at the cashier. So for 145 bracket 3, will you penalize the particular staff a 2,000 fine? Well, this is a mechanism for serving penalty notice and then demand notice. This is a cluster of procedures, and we find it in other ordinances as well. I'm just submitting my observation. After reading these sections all the way to 147, my feeling is that after serving penalty notice, you allow for 21 days to make payment. And at Section 147, if they fail to comply with the penalty notice, you will serve them with a demand notice, and then you can wait for another 10 days. In other words, they have 31 days to make the payment. You will first give them 21 days and then 10 days. If they still fail to comply, there is still no penalty. You are adding on to the administrative burden to the government because you are serving 2 notices, and there is no penalization against that person as well at all. I would like to point this out because the whole procedures here does not just exist in this ordinance. I see this kind of mechanism in many notices. I find it very time-consuming to the administration. Assistant Director. Thank you, Ms. Kong. I understand that you have some comments towards this kind of penalty. First of all, the fixed penalty notice and the related provisions can be found in other ordinances. It is a standard practice. And also, what is the original intent of the promotion of recycling and proper disposal of product Miscellaneous Amendment Bill 2025? Our original intent is to promote recycling. So publicity is our major target. The law enforcement is just our second priority. After 1 year of campaign, we don't really have to serve the penalty notice, not to say the summons. Therefore, in the Division 8, we are putting it here as a protection. We will also provide law enforcement guidelines to our frontline staff because the law enforcement division have been doing it for years. We will not be overreaching, and there will not be arbitrary prosecution because we will have inspection and collect evidence. We will also understand the situation with the person in charge. We will only serve them with fixed penalty notice if there are repeated offenses. Therefore, we are confident that with our law enforcement guidelines and with our understanding of the situation together with this bill here, I believe that it is going to be effective. as mentioned, Division 8 is leading up to 0058. If you have no further questions about the other penalties, I think Ms. Doreen Kwong has some questions that you haven't covered. I'm asking about the frontline staff. That is Section 145, Bracket 3. We will not be penalizing the staff taking our ordinances against plastic utensils. We did serve some fixed penalty notices because there are restaurants who are in violation of the law by serving plastic utensils. We are only serving the boss or the person in charge with such notices. Thank you. I would like to explain with a scenario. At a convenience store, if you are asking for the office address of a company, the company of that convenience store, the staff of that convenience store will not be penalized according to 145 bracket 3. Is that correct? Correct. Mr. Peter Xu? Well, I have spotted something regarding the recovery. Well, if it is being recovered through the machines, you need to calculate the proportion of the recovery. There will be some calculations done. In my impression, I thought that there will be a label and number printed on the container. There will be both a barcode and a logo. Perhaps there will be record with the government through the barcode. And the logo was also printed on the container. So even if the containers are being suppressed, if they need to differentiate what are locally produced product and what are not, they might not be able to scan the barcode, but there is still the logo, so they will know what counts and what doesn't. But if it is in a small quantity, if we are importing in small quantity, sometimes we are just only fixating the logo on it instead of printing it. So it might be just a sticker. So people might be putting the sticker of the logo on it and pretend that it is some locally manufactured product. I'm not sure. By the use of technology, are we able to still scan the barcode after the container is being compressed? If we cannot, then problem would arise because we won't know how to differentiate them. Perhaps before compressing the containers, we need to scan the barcode and do the calculations. This is just a kind reminder for you. This is a reminder for the administration. Ms. Kamen-Khan? Chairman, I think we need to look at 131 bracket 2 and 131 bracket 4. Here are two examples. Can we just discuss these two examples? The administration said that they have singled out these 5 different sections. Let's call it a summary mechanism. You penalize them with a fine of $2,000 instead of serving them with a summons. In 131 bracket 2, may I draw your attention to 131 bracket 2? It is on page 32326. That's for the marked up version. Page 40 in the Chinese version. It involves the intent, the mens rea. If they intend to make people believe that they are selling a registered product, so it might not be a violation of law because it has to prove that they have intention to cause people to believe. So if they want to cause people to believe that they are selling products that are not registered as registered product, in 131 it says that the retailer cannot distribute certain products if they know or they knows or reasonably ought to know that this is a unregistered product. What I want to point out is that it is not strict liability because you need to show mens rea. if you are going to prosecute them, then the administration needs to prove the mens rea. I'm relying on the legal advisor to listen to these comments. The administration needs to prove the mens rea. Why do we still believe that it is appropriate for a fixed penalty notice? Because you need to prove the mens rea. That means if they want to argue against it, they can still do that. If the retailer said, I have no intention to mislead my consumers, they can argue about that. Or they said, I really don't know, or it is not reasonable for me to know. Then they can just reject your fixed penalty notice. What I mean is that this so-called summary notice, when it is in action, the defendants or the people who are served with the fixed penalty notice, they can say that you need to prove my mens rea. And if are they going to argue within this mechanism, or you have to withdraw it first? Because in section 144, you said that it is subjected to 148. So what can we find in section 148? It says that the director may withdraw a penalty notice given or a demand notice served. Please help us understand. Perhaps you should draw a line. Can you just give a penalty notice through a summary mechanism? I don't believe that it will be enforced by the director. You are certainly going to authorize some frontline staff. Perhaps it is the law enforcement team of the EPD. If the defendant or the people who is being served want to argue with you, they can still do that. When you enforce the laws about the plastic utensils, I believe that you have encountered similar situations. And those provisions there may not require you to prove the mens rea, but in 131 and 132, the mens rea are involved. Thank you, Chairman, and thank you, members, for your questions. I can briefly talk about the penalty, and then I will direct it to Mr. Lau. Let's look at the overall penalty. Let's not just focus on Division 8. The penalty of all law contravention, including the fine of level 5, level 6, as well as this fixed penalty notice. Later on, in the provisions for proper disposal of products, we will have an imprisonment of 6 months and a fine of up to $200,000. So let's not just focus on Division 8. If it is a beverage provider, if it is not registered when they distribute products, they might be penalized with a fine of level 6. It has to be ruled by the court because it is rather severe. Or if the scheme operator does not submit the regulatory reports according to the provision, then they are going to penalize with fine level 6. So how about the fixed penalty notice? The retailer can be penalized by $2,000 if they distribute some unregistered beverage. So in Hong Kong, we have a lot of small retailers. Therefore, we have provided some space for them. Perhaps they are accidentally selling some products without a label. If they are in contravention of the law, we will serve them with fixed penalty notice and we will give them a chance to correct it. If they do not correct themselves, then we will serve them with summons. But for the suppliers, if they are offering beverages without registering, we can be speaking of some really large scale of operation. It could be hundreds of millions of beverages or tons of products. That's why it has to be fined by a level 6 fines. Therefore, when we look at this statutory penalty, there are different levels. And our frontline staff, when they enforce the law, there will be guidelines provided, and there are also precedents for them to follow. All these penalties are being scrutinized by the OJ. And Chairman, I would like to clarify a point. You're talking about 131 and 132, and they are not mild at all. You're talking about fine of level 6. If you look at 131 bracket 2 and 132 bracket 4.
It is exactly what we said earlier. We first would ask them to pay a fixed penalty, and if they do not rectify their ways, there will be follow-up actions taken. But say for plastic beverage containers, it would go straight to a level 6 fine, say a scheme operator distributing a non-compliant product. So there are different levels of offenses. Say for disposable cutlery, when restaurants are issued with fixed penalty notices, they rectify their ways pretty much right away. So for non-compliant products to be issued, we plan to have the issuance of fixed penalty notices be the first step, and if they do not rectify their ways, there will be a fine handed out by the court at level 6. Thank you. I think the DOJ colleague will also supplement my answers. We are indeed consulted on the mechanism. Those issuing fixed penalty notices should know very clearly whether to issue fixed penalty notices under certain circumstances. And if they are capable of issuing fixed penalty notices, in law there is nothing really stopping them. For 146, page 51. If relevant parties do not pay the fixed penalties, the director may serve demand notices. And the director may serve on the person a notice informing the person that the person must notify the director if the person wishes to dispute liability for the offense. So if one does not pay because they wish to dispute liability, the director should be notified. And in section 154, in subsection 1, paragraph A, if a person has notified the director in accordance with a demand notice that the person wishes to dispute liability for an offense, this section applies. And in subsection 2, it actually says how a summons issued may be served on the person. For your consideration, member. Thank you. Assistant Director, please go on. We have completed scrutiny of Subdivision 8. We can now talk about Subdivision 9 or Division 9 supplementary provisions. Section 158, burden of proof. We have answered the letter sent to us. Basically, if one has to raise a defense in relation to Part 7, if there is adequate evidence to raise an issue, it would have been seen as a defense being established. This is just the legal principle. And for section 159, as said earlier, we will now adopt a positive vetting approach rather than a negative vetting approach. We will first consult the panel on environmental affairs, and then we'll adopt the positive vetting procedure with the passage of relevant legislation. Excuse me, please pause here, Ms. Carmen Khan. I want to ask about section 157. The Legislative Council may by resolution amend the amount specified. Why is this provision necessary? Well, when we're talking about the amount, it is the amount of the fixed penalty. Say for section 143.2, it is the $2,000 fixed penalty. So if we want to increase the penalty, maybe due to inflation or us wanting to increase the deterrence effect, we may want to increase the amount via positive vetting of the council. This is consistent with the approach in other legislation with the amending of the amounts of fines. Next, from page 62 to 76 of the marked up copy in Chinese, it is Schedule 12. Right now it is blank. And afterwards we will, in accordance with section 160, when the time is right, we will introduce amendments to Schedule 12 with positive vetting. So we are putting the framework here in Schedule 12 at the moment. Pages 63 to 76 of the marked up copy in Chinese, we have some textual changes. We would have the Chinese term 月光 substituted by 毛色. Basically, they mean the same thing, but it is a change with the drafting practice. I don't think there's going to be much dispute on this. From page 77 to 104 of the marked up copy in Chinese. At the second meeting, we talked about how for plastic bags, we now have, before prescribed forms, now we're using specified forms. So for the 10 odd pages of the plastic shopping bags regulation, they are the prescribed forms. As we said earlier, we will replace the use of prescribed forms by specified forms. The whole regulation will be repealed. Next, page 106 of the marked up copy in Chinese. We have amendments to the waste disposal ordinance. The waste disposal ordinance does not include the 5 products. We need to amend the legislation and the subsidiary legislation of the ordinance to cover the new types of wastes: plastic waste, liquid cotton waste, vehicle tire waste, EV battery waste, etc. Please stop here, Ms. Kamen Khan. Now, you are switching to the approach of positive vetting. But in section 159 and section 160, it says right now, say in section 160, Secretary may amend Schedule 12. Right now, Schedule 12 does not have any items. And it is said here the Secretary may, after consultation with the Advisory Council on the Environment by notice published in the Gazette, amend Schedule 12. How would you make sure, apart from consulting the Advisory Council on the Environment, you would consult the Legislative Council? And when you talk about switching to a positive vetting approach, how will that be presented in the bill? I also want to ask about page 62 of the marked up copy in Chinese. We would have some of the wording, the provisions applicable to different products stated in part 2. So we did say earlier in section 140 for rebate related provisions, It is said by the representative earlier that they would have for different products different rebate arrangements. Would they spell the arrangements out in Schedule 12? I'm just presuming this. How are you actually going to set up details for the different products? Thank you. Assistant Director, thank you. For sections 159 and 160, we will switch to a positive vetting approach from a negative vetting approach. We have had preliminary discussions with the DOJ. Say for section 159, we will add a subsection 2 to say that any changes would be scrutinized by the Legislative Council, and we would also add a subsection 3 to section 160 that approval needs to be obtained from the Council. So that should achieve our intended effect. Ms. Common Khan's understanding about Schedule 12 is correct. So say for a particular type of product, we would have it spelled out in column 2, and in column 3 we would say, for example, the logo arrangements. Say for section 131, we would say that in column 3, 131. And if rebates have to be provided, say in accordance with the particular section, section 140, we would include that section in column 3. It's basically depending on the provisions needed. We will include them here. So when notices are issued or published, before that, approval would have to be obtained from the Council. So in future, we would also be able to scrutinize the particular provisions that you plan to include in Schedule 12. Correct. I think we may have other products to be covered on top of the 5 products in future. If we have to cover more products, the government may include them in Schedule 2, and they have to consult us, right? Yes. Mr. Income. I want to ask about the waste disposal ordinance, the definitions. Page 94 of the English marked up copy and page 107 of the marked up copy in Chinese. Now for EV battery, you said in particular it is waste that will not be produced, will not be producing emissions, basically. I have done some research. It's not the case that all pure electric vehicles will emit no air pollutants. And according to a journal, from the brake from the tires, air pollutants will be emitted. I also note in other places for the definitions of pure electric vehicles, they wouldn't be so ambitious. They would only say emit low amounts of air pollutants. So why did you have such definition here? Have you had a similar definition in other provisions? Thank you, Mr. In Kong, for your questions. For the definition of pure electric vehicle, we have had a particular section, the air quality section of the EPD. They note that electric vehicles in Hong Kong are propelled by batteries, and we are drawing a comparison of the vehicles with diesel vehicles. Diesel vehicles would emit various types of air pollutants. So electric vehicles would not emit the particular air pollutants, which is why we have included this definition here. I think Mr. Ring can't understand what you're saying, but the definition is a bit far-reaching. So this is also just a definition derived with reference to EPD officers' understanding. Have you consulted other departments when you give such a clear-cut definition? Well, we will review Ms. Doreen Kong's suggestions. I guess Ms. Doreen Kong is thinking when some air pollutants are emitted, what is going to happen? Mr. Andrew Lam. I think you said in particular there are tires that are vehicle tire waste is supposed to be abandoned. Why did you include this part here? We are trying to include this part because we want to include tires of airplanes or the ones that are filled, which is why we say in particular for the tires they should be filled with air. I don't understand why you're not including tires that are filled with contents. I don't really understand, because unless you can't regulate them, why do you not cover them, the pneumatic tires? Well, for the industrial tires or the tires, pneumatic tires that are filled with contents, the diameter can be quite huge. The downstream operators cannot break these tires up with their machines because of their large size. I understand that it is very difficult to recycle such tires at the moment altogether. We want to make sure there is proper disposal of the relevant products and try to recycle as much as possible the relevant products, which is why we have limited the scope of regulation at the moment. Alright, next, Mr. Ring Kong. I want to ask the administration. This is basically the first round of amendment exercise. And then you are going to make amendments in relation to import and export permits. We do have some related provisions in this bill. I want to make sure these changes also match the policy vision. Assistant Director, maybe I can talk about, say, in page 106 of the marked up copy in Chinese, we have included some definitions. We talked about them earlier. We also can look at page 107. We have a definition of vehicle tire. We have made reference to the road traffic ordinance. We have also various definitions that are included in page 107 of the marked up copy in Chinese. If I may, please pause here. For liquid cotton waste and plastic waste, as well as vehicle tire, the definitions or vehicle tire waste, these will be regulated under Schedule 12, right? Assistant Director. The member asked us earlier why we have to amend the waste disposal ordinance. It is because When we first launched the producer responsibility schemes, we want to have from the beginning to the end in the process some regulation. And for supplying and recycling, we have regulation for the suppliers down to the downstream operators, what they have to do to ensure proper disposal of the products. So for the products, the 5 types of products to be regulated, the disposal, the supply of which will be regulated from the beginning to the end. And we have to control the disposal when the products are supplied. Say for plastic bottles, we have to make sure licenses are obtained not only for plastic bottles but also plastic waste, because it may not be limited to plastic bottles, the products supplied. So we want to have a broad scope. As long as one is dealing with plastic waste, one should obtain a license. Thank you.
Deputy Director understands what I was asking about. He gave a very clear answer. Thank you. Well, recyclers don't have to obtain a license in the downstream. If one only needs to obtain a license when one deals with waste plastics. Just now I asked about the definition, but the Deputy Director said the scope is actually very wide. What about water-filled barriers? They are made of plastic as well. When it comes to rebates, or for the types of plastic that are covered under this ordinance, one needs to obtain a license before one can handle these plastic products or plastics. Can the Deputy Director or Assistant Director take us through the relevant provisions? All right. In subsequent provisions, we will come to that. Should we scrutinize the clauses one by one first? All right. Just now we were on 0107. And 0108 we were talking about plastic waste or rubber waste. The next amendment is on page 0110. There are currently different provisions, and for the waste, well, we have added EG to EJ. Container waste, liquid carton waste, vehicle tire waste. We have drawn reference from brackets EA in relation to the size, and we have drawn reference from existing provisions. Hang on, Ms. Carmen Kan, followed by Mr. Chen. Thank you, Chairman. There's a series of definitions. Are styrofoam boxes covered as well? Assistant Director, yes, they are plastics as well. Yes, they are plastic waste as well. Thank you. Mr. Chen? I'd like to ask about 107 on the definition of waste, plastic waste, container waste, liquid carton waste, vehicle tire waste are covered. And we're going to touch upon the battery waste of EVs, electric vehicles. Can the administration let us know, for the sake of completeness, batteries of EVs have been covered under chemical waste, and the relevant provisions or regulations apply. So for the new types of waste, you didn't set up battery waste. Is my understanding correct? I will ask Mr. Lee to answer your question. Yes, indeed. Battery waste, that is chemical waste, is subject to regulation now. Thank you. Just now we talked about licenses. On page 111 of the Chinese markup copy, we have added 3 types of waste. That is container waste, liquid carton waste, and vehicle tire waste. Under 2F, after consulting the ACE, EG, EH, EI, and EJ are very important provisions. So I do think we need to seek approval from the Legislative Council. All right. Page 112 is about textual amendments. It's about amendment to the glass waste. We want to make sure the provisions are consistent, and these are textual amendments. On to the next amendment, 0116. The textual amendments are the same, so I believe there shouldn't be much controversy. Thank you. Regarding 0112, I'd like to know why D is struck out. That is container waste. Why is it struck out? We used to have the glass waste producer responsibility scheme, and glass waste container did refer to glass waste. Now we cannot confine the definition to glass. That's exactly why we need to expand the definition. As a result, it's a textual amendment. In other words, for any types of waste, for any waste being imported into Hong Kong, one needs to obtain a license. Is that correct? Under 12A, for different types of waste being imported into Hong Kong, there need to be different requirements. Take plastic beverage containers as an example. According to Basel Convention, one does not need to obtain a license. For other types of waste, I will ask Mr. Lee to give you further information. Waste Disposal Ordinance, there is Schedule 6, 7, and 7A. When waste is clean, one doesn't have to obtain license. Based on my understanding, under PRS, well, 7A should be regulated waste. For 12B, likewise, they will be regulated as well. Mr. Chen, Now we have hydrogen fuel EVs, and later on we may have to dispose of the relevant waste. Earlier on in the gas safety ordinance, we already scrutinized relevant definitions. There needs to be a test to certify their roadworthiness. If the waste needs to be handled, there are mainly two parts. One, a battery conversion system. For the other types of battery, the handling is easier. For example, for lithium battery, it's simpler. So it's how do you dispose of it if it is not written in the regulation? Thank you. Regarding the producer responsibility scheme, it covers different types of waste. We need to cover the disposal of different waste as well. Say for the producer responsibility scheme, we haven't yet factored in hydrogen fuel cell batteries. So whether it's about the producer responsibility scheme or not, when the time is right, we will make amendments to this ordinance. Thank you. Of course, it'd be good if we can make all the amendments in one go, taking the opportunity of this legislative exercise. Mr. Chen? I understand it's in a trial stage, and the relevant gas safety ordinance has been scrutinized. It will be passed by Legislative very soon. Say for hydrogen fuel cell vehicles or robots, they will be permitted to be operated in construction sites in Hong Kong. As I understand, the administration takes the opportunity of future applications to test out these technologies. Regarding whether we need to fine-tune or make minor adjustments to legislation, we'll see later on. I understand the administration will handle all these and scrutinize the relevant provisions later on in tandem. Just now we were on page 116. Next, 0120. Under 21A, as the Deputy Director said, we have to expand the coverage. We can see container waste, plastic waste, liquid carton waste, vehicle tire waste, or electric vehicle battery waste. So these are consistent with the expanded coverage mentioned just now. Next, 0121. Regarding the sixth schedule, we'll have to add one more definition. Mainly, it's about different types of glass. For colored and other waste or scrap of glass, we have to add container waste, referring to the container waste of glass. We need to make sure the importation and the export are regulated. And that is actually textual amendment in relation to other types of waste. 0123, 0124. these are relevant amendments to the schedule. Take 0124 as an example. We add 3 types of waste, that is container waste, liquid carton waste, and vehicle tire waste. There is a requirement to obtain import and export license, and that is page 110 on the English version. On to page 125 on the Chinese copy, that is an amendment to the Chinese version, changing Yagong to Mause, and that is just a Chinese textual amendment. Ms. Carmen Khan, I'd like to ask about page 0124. Why don't you include plastic waste as well? Mr. Lee, according to Basel Convention, just now as we mentioned under PRS, we allow the import and export of plastic waste in accordance with Basel Convention. We need to comply with international conventions. Plastic bottles may be crumbled or crushed. Ms. Carmen Khan has a question, that is whether this will lead to confusion. Some provisions covered plastic bottles, and you are making amendments to all these provisions. We are actually referring to containers of glass or glass bottles. Ms. Carmen Khan asked why we didn't cover plastic waste. We didn't actually cover plastic waste whenever we, well, hang on, Mr. Lee, I understand. If a provision concerns glass, plastic, and so on, then you don't use the term container waste. You need to make it clear. But as this provision only covers glass waste or glass bottles, that's exactly why you only use container waste. You make it clear it's glass bottles under the PRS so that you won't simply use the word container waste to avoid confusion. Earlier on page 112, when we were talking about the import and export, we used the word waste, and the definition of waste covers all types of waste, tire, beverage container, and so on. So the word waste has a very wide definition. However, when it comes to 7A, you break down and have very fine definitions. So I just now asked about the lack of plastic waste in Schedule 7A, and Mr. Lee gave an explanation about the Basel Convention. For plastic bottles, they can be imported and exported. What about for non-plastic waste? I mean, for non-plastic bottles, what about other types of plastic waste? According to Basel Convention, if plastic bottles are mixed with other substances, they cannot be imported or exported. It's about the mechanisms for obtaining licenses. So you mean one cannot obtain a license? Is that correct? Yes, indeed. One needs to obtain a license before these types of waste can be imported, or these types of plastic bottles can be imported or exported. When it comes to Schedule 6A, we will have to take into account the reason for import and export and whether they have been polluted. When it comes to green waste, however, if it's mixed with other substances, we won't issue licenses, and that is in accordance with the Basel Convention. However, if it is a plastic bottle mixed with other types of substances in the course of recovery, we wouldn't require the relevant person to obtain a license. In other words, one needs to meet the definition of green waste before it can be imported and exported. If one doesn't meet the requirement of 6A, then one cannot import or export the relevant waste. Is that correct? Well, if something is not under Schedule 6A, it cannot be imported or exported. So it couldn't be imported or exported. Is that correct? Right.
Deputy Director, to page 125 and on page 126, 127, 128, we are all changing these terminologies. Or to the page 129, we are changing the word government to the Hong Kong SAR government, and it is also applicable to 130, 131, 132, 133, 134, and 135. Now we are at page 0136. We are amending the subsidiary legislature L because we have added vehicle ties waste. Therefore, the premises cannot receive battery waste because after WEEE, landfills cannot receive any WEEE waste. As we have discussed during the policy discussion, in the future, when we roll out the scheme for vehicle tie waste disposal, it cannot be put to the landfill. Therefore, we have to add it in Cap 354L. It will be effective as we roll out the ordinances of vehicle ties waste. 137 from government to Hong Kong SAR government, as well as on 138. This is the end of the scrutinization. Is there any further questions? If not, then we are thankful for the introduction of the government. See if there is any CSA being proposed. Any questions from the legal advisors or any questions about the English version? Thank you, Chairman. The legal advice department has checked the English version and there is no discrepancies. As mentioned at the meeting, the administration said that there will be amendments to the bills by the administration. The subsidiary legislation will be changed from negative vetting to positive vetting. Upon receiving the CSA from the administration, we will look into the drafting to see if there is any matters to be followed up. I've asked if there is any CSA from the members. I believe that you have already submitted your comments to the administration, and the administration is welcome to it, and the administration will propose it on CSA. Ms. Doreen Kong has asked about EV. Perhaps you can look into the definitions. If there is any amendments, please let us know. So the administration will prepare for the CSA. When it is completed, perhaps you can first circulate the paper among the members. If necessary, then we will convene another meeting. Mr. Rincon? Chairman, I have one question. As mentioned yesterday, I've asked about the retailers. I hope that they only need to check if there is any prescribed logo and barcode. I hope that they will not be burdened to check if it is a compliant product. I would like to suggest the administration to consider that. Yes, we will consider that. So there are items that they need to consider. And when they come to a conclusion, I believe that they will inform members. Perhaps we can wait until the administration has prepared CSA, and we will circulate it among this committee. If necessary, we will convene another meeting. Ms. Lillian Kwok. Thank you, Chairman. I would like to remind the administration. We have discussed about the rebate and penalty. A lot of frontline salespersons may not know all the details. upon the passing of this law, there will be a lot of publicity and education works. I hope that you can consider the large population who are involved in the retailing businesses. Please let them know that they have no liability here. Next, our timetable. When do you wish to resume the second reading? Deputy Director, we hope that second reading will be resumed on the 23rd of July this year. Any comments from the members? But of course, we need to wait to see if there is another meeting, and we need to wait until we receive the CSA from the government. Ms. Carmen Khan? If we are going to resume the second reading on the 23rd of July, then should the common legislative framework needs to be effective first? Then through the positive vetting procedures, then you would submit product by product. Is that your plan? Shall we see the common legislation be effective first, and then during the trial period through the trade, we will continue to go through the legislation? Is that the case? I would like to invite the Deputy Director to explain it, because first of all, we need to have the common legislative framework and then the subsidiary legislation. But now the format has changed. Perhaps members will be interested when we need to roll out the legislation for each product. What will be the procedures? Thank you, Chairman. Well, after the second and third reading of this common legislative framework, it will become legislation. Then we will be authorized to work on the subsidiary legislation. Taking the plastic beverage containers as an example, it will have its own subsidiary legislation. In that process, we will iron out the execution details with the trade. After we have confirmed everything, we will submit it to the Legislative Council as a subsidiary legislation. That is why it is called positive vetting. The Council can set up a committee to look into the subsidiary legislation. Upon the passing of the subsidiary legislation, then PRS can be formally rolled out. It is clear. Mr. Lo Wai Kwok? Thank you, Chairman. This is almost reaching the end of the scrutiny of the legislation. I would like to compliment on the administration because they are taking in our comments. This framework concerns the promotion of recycling and PRS. I do support the administration work, but still, it is just a framework. When you have to go into the details of each and every product, it is actually very complex. Even this morning, members are asking the question that indicates the complexity of this issue. Even if you are just talking about plastic beverage containers, we would have products that are manufactured locally or in the mainland. Sometimes the logo is printed on the bottle, and sometimes it is just being stuck as a label. And sometimes the containers are being compressed and not compressed, and there are also issues of reading the barcode properly. So, be it positive or negative vetting, I think even if you go through negative vetting, it might not speed up the process a lot. Well, if you're trying to save time through negative vetting, I don't believe it is ideal for the Legislative Council. But if we are able to go through it through positive vetting, it will be more reassuring to the trade. Even if you are going through negative vetting, you will still put into a lot of effort in communicating with the trade. But now, as you're changing it to positive vetting, it is giving all of us a peace of mind. It will be more helpful to our future process. Mr. Chen So-hong, thank you, Chairman. Up to this stage, I think we are wrapping up our work, and we are all happy to see the formation of the major framework. I am confident that the administration will have good communications with the related trades. And I believe that the first product will concern plastic beverage containers as well as beverage cartons. It will go through the positive vetting process. Basically, the trades do support the setting up of this framework together with the subsidiary legislation regulating the manufacturing of plastic beverage containers and beverage cartons. On one hand, they do support about the PRS as well as the concerns. I hope that when you are in discussion with the trades, please consider if you will put in place an appropriate transition period. Because as we implement previous ordinances, practically speaking, it does require a certain period of time for the trades to adjust to it, and it also takes time for proper law enforcement. Please do consider it. Would you consider an appropriate transitional period so that the trade can be fully prepared to fulfill their duties? Deputy Director, the process has begun. We have been in discussion with the trade for a long period of time because it is the first time for us to adopt a market-led approach. We are taking one step at a time since it is our first time. Even before the transitional period, we will first put in place a preparational period. People can start to register and submit the report or to discuss with the scheme operators and to set up return points. And then we will enter into the transitional period. We will allow for some space since it is a trial period. Well, because you would have different imaginations about the scope of recovery. So is this network sufficient? It does take time for us to tell. Therefore, we will allow for a reasonable trial period, and then it will be fully executed. Mr. Andrew Lam, the implementation of PRS is a process that we need to take one step at a time. And I hope that the administration will continue to follow up on the issues of cross-boundary sales, especially the sales through cross-boundary platform. The inventory will be in Hong Kong and the delivery will also be conducted in Hong Kong. What will be the future trend of that? I hope that the administration will take notes and continue to follow up. Yes, it needs to be noted. Mr. Andrew Lam and Peter Shill has both mentioned about this trend. Mr. Peter Shill, and then the legal advisor. Well, Chairman, since everybody is giving their comments, perhaps I should also submit mine. I believe that everyone is supportive of environmental protection, but it is costly. About who is going to pay for it. For the plastic beverage containers and beverage cartons, I hope that it can be transferred to the general public in Hong Kong. As estimated by the trades, at this moment, they expect that the cost of each beverage containers and cartons will be about 50 cents. That means since you are all supportive of environmental protection, then maybe in the future, when you consume such drinks, you have to pay an additional 50 cents. Well, but we all understand about the trend of cross-boundary e-commerce platform. So it is enough for just the Hong Kong public to share the cost. As we look into the development of other industries, we know that this is not the case. Since there is cross-boundary sales, the local retailers knows that the cost cannot be transferred to the general public. This is why the industry is facing huge challenges because it is very difficult for them to conduct businesses. In the future, if there is additional cost to our drinks, then our competitors will have a competitive edge. Maybe at the end of the day, the general public would choose to purchase from them instead of the local manufacturers. Then it will pose impact to the economy of Hong Kong. Early this morning, I have received a message from a friend urging me to voice this out. And also about the calculation of the containers. If we are all using machines, it will be fairer because we are just scanning the barcode. But if not, it might be quite tiresome, especially when the plastic beverage containers are being compressed. I really don't know how can you scan the barcode. Please take note of that. Mr. Benson, look. I would like to compliment on the efforts of the administration. Just now, as mentioned by my party leader, before the scrutinization of the legislation, some trades members have met with us and they have expressed different concerns and worries. For instance, would there be containers importing from other locations? Because if that is the case, we would defeat our original target of protecting the environment. Under the leadership of the chairman, the administration is able to clear the air. I understand that the target of this ordinance is not to penalize those who misbehave. We just want to reduce the overall waste quantity in Hong Kong. After the passing of this legislation, I hope that in due time, the legislation will continue to assess the effectiveness of this legislation. Thank you. Mr. Kwok Wai Kang. Thank you, Chairman. Previously, when the PRS is led by the government, we are focusing on the surcharges, and it requires a lot of effort on behalf of the government. Perhaps it even involves some additional costs. And now we are finally adopting a market-led PRS, which I have proposed repeatedly at this council. I have shared about our experience in Korea. I have repeatedly mentioned the example of that package bag of potato chips, and I'm so glad that it is now being implemented in Hong Kong. As Mr. Shiu said, to protect the environment is costly, but the user shall pay for it. We shall not pay for it from the public coffin. I believe that this is the overarching principle that we all agree. But of course, we all concerned about creating additional job opportunities. After implementing this market approach, I hope that when the manufacturers is trying to recover the target quantity, perhaps we can all spare some effort to think of the proper handling of the recovered waste. If we can handle it locally, it will be the best, because we are all about innovation and technology. Nowadays, we only talk about AI and high technology. However, transferring these waste into some useful materials. Let's say in Germany, they are turning these waste into construction materials. Or there might be some special designs in such usage. I hope that there will be more rooms for more rooms of development in both the circulation and the market.
Ms. Doreen Kong. I thank the chairman for giving me the opportunity to speak again. I do understand the administration will review my suggestions in relation to, say, the retailer arrangement. I very much appreciate that. I agree that we need to take a step forward in going green and recycling. But the citizens are concerned about the details of implementation. When I look at the practices of other places, there is an emphasis on product life cycles. They are much more forward-looking than we are. They are already thinking about reusing the product package when they manufacture the packages. Regardless, I think we can see if there is any room for improvement in future, and if we are taking another step in future, I hope that retailers won't be burdened, because with the responsibility of going green in other places, it is actually very clear that retailers will not be regulated because the source of the products is not retailers. They are not the main drivers in this. So I hope the administration can be more lax with retailers in future. Legal advisor. Thank you, Chair. Ms. Kamen Khan asked earlier about the commencement arrangements. The bill's provisions won't commence right away after passage of the bill because some provisions, according to subsection 3 of clause 1, it said that some provisions are to come into operation on a date to be appointed by the Secretary for Environment and Ecology by notice published in the Gazette, and some subsidiary legislation may be promulgated by the Secretary later. I think to avoid any disputes, why not have the Secretary commence the ordinance by notice published in the Gazette and then have other provisions commenced by notice published in the Gazette as well, rather than relying on immediately after third reading of the bill, the ordinance is to commence, or the bill is to commence. Assistant Director. Thank you. Actually, in part 1 of the bill, we said for clause 1, subclause 3, some particular sections that are going to come into operation after the common legislative framework has come into effect. Let me give you an example. Say for waste disposal ordinance amendments, we have for vehicle tire waste no longer going to the landfills, and we are amending Chapter 354L accordingly. It is because we have to wait until the arrangement comes into operation before we introduce the amendments in Chapter 354L. And in Clause 1, subclause 3, we have some sections that are to come into operation on a date to be appointed by the Secretary for Environment and Ecology by notice published in the Gazette. All right, that much is clear. Any further comments from members? If not, any other business? I want to ask when the administration will submit the draft CSAs to us, because we may convene another meeting if members have further comments. We do have another date fixed on the 27th. So can you submit the draft CSAs before the 27th? We should be able to submit the draft CSAs by this week. All right. Great. Thank you. Thank you for submitting them to us this soon. And when the amendments are received by the Secretariat, they will be circulated among members. As for the date of the next meeting, we may convene another meeting if necessary to look at the draft CSAs. I thank everyone for your hard work in scrutinizing the bill. I also thank the administration for accepting much of the feedback given by the members. We'll wait for your draft CSAs. Meeting adjourned. Thank you everyone for attending this meeting.